Hi there, this is Helen Tarrant again from LA. Here with our whole team. Wow, it's massive. Welcome to another episode of Commercial Property Roadshow. Here with Helen Tarrant. I'm actually here with Nathan and from
ABP Lawyers.
There you go. Not because I've forgotten the name, but it's because it's always good to give your business a plug. But the idea today is there is a lot of things that people talk about in the commercial space, especially about how you deal with problematic tenants, especially how you kick out a tenant and put in a new one. Putting in a new one is easy because you give them some lease incentives and you write a lease, right? But what if you just have an underperforming tenant? And this is really important when you guys are looking at uplift properties, right? Uplift properties, at some point you may need to switch out a tenant. At some point you may need to kick out a tenant. At some point you may need to terminate a lease, especially when you're inheriting someone's problem, right? So, I think we're all wearing beige today, so we're all a bit beiged out today. But anyway, so tell me, Nathan, what happens if someone comes to you and says, look, my tenant's not paying rent, they're underperforming, or that, they're just not doing what they're meant to do?
Yep. So it's not a one size fits all. First of all, it depends on the lease agreement that you've signed with the tenant, and it depends on whether it's a commercial or retail lease. So there is a difference between the two. The retail lease is governed by the Retail Leases Act, and the retail tenant actually gets a little bit more rights than a commercial tenant. So it depends on the circumstances. But typically, if a tenant has defaulted on the lease, what you do is you normally give them a heads up by way of a notice. So the notice will give the tenants a heads up as to what default they have actually made and the time frame that they have to rectify. So
that's like an essential part of the lease. So when you look at people signing leases, normally this is some essential parts, like they've got to pay rent, right?
Yeah.
It's number one.
Essential terms.
Essential term. They've got to pay some outgoings.
Yeah.
That's an essential term.
Yeah. Not damage the premises.
Not damage the premise. That's an essential term.
Buy insurance.
Buy insurance. Okay. And not damage, some maintenance. Things like, potentially other breaches that they could have. I know that in Strata we often see some issues when we go through the Strata searches and reports that sometimes, their parking areas, they put their shipping containers across parking spaces, like all sorts of stuff that really irks the Strata, and we can technically kick the tenant out. But so not creating problem for other tenants, right? Pretty much. Yeah.
So it really, as a landlord, what is important to you is that the tenant pays their dues in accordance with the lease, and also they don't damage your premises. So those are probably two of the main things that most landlords care about. Obviously, as long as they don't impact on other aspects of your business, which is renting out the premises.
Yeah, so basically, as much as you can, it's basically your tenant has to pay rent. So in the instance they don't pay rent, you're giving them a notice. So the notice basically says, hey, you didn't pay rent last month or 2 months, or so what time frame do you give them that notice?
It depends on, as I say, what type of lease it is,
but call it just normal.
Generally it's lease. Between 14 and 30 days that you have to give them a heads up, and if they don't comply within that time frame, you can actually terminate that lease by a notice of termination.
Okay, so if my tenant, say, 1st of July, I bought the property 1st of July, and we're now in August, so they didn't pay rent in July, right? And then now obviously we're on the 6th of August or 9th of August now. I can't remember my date, but we now send them out the notice pretty much because they really haven't paid rent for July. Yeah. So we send them out a notice now, and we give them 14 days roughly notice for them to rectify paying us rent.
Exactly.
So let's just say then they didn't pay us rent, and now we're towards the end of August. What happens now?
Well, if they haven't complied with the notice to rectify the breach, then you can issue a notice of termination. And the notice of termination just pretty much tells them that the lease is at an end and they have to vacate the premises and make good in accordance with that lease.
All right, so therefore, then that's when you kick your tenant out. And when do you terminate their lease, but then what happens if, say, they still have 3 or 5 years to go on the lease? Do you sue them for the balance of that lease?
So you normally have a security deposit. So
Yeah.
you can first claim against the security deposit if it's insufficient to cover the the loss that you have incurred, which can include the cost of rectifying the make good, the cost of any unpaid rent, as well as any incentive that you may have to pay to the next tenant. So if you are actually paying 3 months rent free to get the next tenant in, you can also add that to your damages as well. So you can either make a claim against the lessee as well as a personal guarantor if you have a personal guarantee in place.
Okay. So then, so if, say, you needed to kick out the tenant and the tenant left all their fit out there,
Yep.
and the next tenant is going to be a totally different tenant, which means you have to strip out that, then they still have 2 or 3 years left on the lease. That's when, and like, let's say they don't even have, they may or may not have a personal guarantee. They may not. Let's say in the instant they don't have a personal guarantee. We know that if they do, you go after them. But if they don't, you have to go after the company.
Yeah.
That's your lease. So you can go after them after all those costs,
You
right?
can.
Yeah.
You can. Yeah.
Obviously, you have to minimize that, right? You have to by try to tenant it.
Yeah, you have to what's called mitigate the loss, which means that you have to try your best and provide evidence that you have, to the best of your ability, marketed that property as soon as possible in as many ways as you can to justify you charging that loss towards that tenant.
Yeah, okay. So you got to minimize your loss, which is important. So let's say that the tenant owes you, by the end of all this, you've done it, you put the new tenant, there's a 50K deficit, right? So you then go after the tenant for that
Yeah.
50K. Yeah. And you may or may not recover it, and not. What we try to do is obviously and we've seen situations even with our clients where this has happened during COVID, and the new tenant they put in is actually a better tenant. So at which point there is no real suit, right? Because if you're putting in better tenant, now the property is worth more. It's sort of slightly the argument then it becomes.
Well, the suit is whatever loss that you've incurred above the security deposit you get, which is, as I said, any make good that
Yeah.
you've had to rectify, any unpaid lease
Yeah.
rental or outgoings, as well as any incentive you've provided to the next tenant. Just keep in mind that you can't just make good the premises. There's actually a procedure that you have to go through. So you actually have to give the tenant the right to come and actually take that make good and take any of the equipment away.
Yeah.
If they don't take that equipment away, you actually have to list every item of the equipment to make sure that you can, anything that is of value, you have to justify the value and potentially have to sell that those equipment and recover that to pay whatever damages that you've suffered. So it's not a straightforward process, but generally speaking, any loss that you incurred, you can claim against the tenant.
Yeah, and then once they've sort of terminated the contract, you pretty much lock them out, right? You change the key.
Yeah, so if you have gone through the correct process in accordance with the lease, and if applicable to in accordance with the act, then you pretty much on termination of the lease change the lock. It's not like a residential tenancy agreement where you have to get the tribunal's order to kick that tenant out and get a sheriff involved. So with a commercial lease, it's much easier and simpler. Just go in and change the lock once you've correctly issued the notice of termination.
Yeah. Well, that makes kicking a tenant out easy, but I know the road to evicting a tenant is never easy because there's a lot of considerations. So most people are scared of that vacancy that comes up, and this is where you need professional help. So you need professional guidance, finding a solicitor or a lawyer that is really proactive, finding a solicitor lawyer who actually specializes in property law versus someone who does it on the side. They might be, they might do family law. It might be someone you've consulted before who does family law, who you use and you think maybe they can help you with a lease, but that's not the right avenue. You really need to consult someone who is more specialist in that property law space, which is, one of the reasons that we work with Nathan with our clients on our commercial property dealings, and he can help our clients in terms of if we need to evicting a tenant, putting a new tenant in there, and having the right advice, right?
Yeah, so we're here always to support Helen's clients in relation to any property needs that they have. We're pretty much part of the team. We work very closely together.
Yeah. And look, it's about having the result. Like whether you evict the tenant now, sooner or later, is a personal decision, but it's something that you need to discuss and also strategize about, because it's money on the line, right? If you going to kick the tenant now versus like I've had a situation where someone chose to not evict the tenant for a long time because they wanted to accumulate that loss, and it was sort of because of all this made good. There was a reason for them to do it. Then I've got someone who, I mean, normally I would just go, if they're not performing, kick them out, lock the doors, and then just get on with it, right?
Yeah.
Because you never make up for lost rent. But delaying that process is sort of it's for some people it's an advantage, for some people it's not.
Yeah.
And ultimately, it's your personal decision, and something that if you're going through this, or if you are looking for some help in this area, or if you're looking at a property that you're actually going to take on that the tenant has gone and you're not sure, reach out to us, you know, helentarrant.com and
ABP Lawyers.
There you go. How do they find you?
abplaw.com.au. And just to cap off, you know, if as Kellen was saying, if you have any tenants that are delinquent or are defaulting on the contract, you really need to ask for professional advice. Helen's team can provide you with advice, because we had tenants who are long-term tenants and they were defaulting because of COVID-19, and they were just going through a tough time in the business. So you may not want to have to look at the situation and assess on a case-by-case scenario. So Helen's team can give you professional advice on what to do in each individual situation, because each situation is unique.
Yeah, and look, Nathan doesn't just operate in Sydney, in New South Wales, he operates across Queensland as well. So a lot of our clients have Queensland property. So if you're in a different state and you want that helping hand, do reach out to us, helentarrant.com, and we'll post details about Nathan's company below. And in the meantime, you know, hit the bell, subscribe, let us know if this has been helpful, let us know what other topics you want us to cover, and we'll see you in the next video. Bye for
Thanks,
now.
guys. Bye.